Yes, you do. Here, you want to see? Use the camera. back of your head is beautiful. You're gonna love the back of your head. We all just stare at each other. David, do you want me?
Why don't you send me the other side of town? I'm both John. David?
Great, thank you. Hi, how you doing?
Brian.
Fine.
I'm sure. Oh, I don't know. Usually it's just one of them. They're usually not both there. Right?
Email them.
Yannetti, California attorneys, are they going to be on Zoom?
They'll be on Zoom, but they won't be arguing.
Okay.
Oh, he was here earlier.
He's Greg Henning.
Can you make one to Zoom?
Do you want to be on Zoom?
Not really.
That's fine.
Hello.
Hat off, sir. Sir, take your hat off.
Thank you.
Not today, just filing.
All right. Thanks, Greg.
Thank you.
True, you used to work in Suffolk with Margaret.
You are unmuted.
Didn't see her down here today. Just TV? TV only.
Paul, I'll catch up on.
Motion to future? I don't know that. Thank you.
Quietly. Just remind the folks about the cell phone use. About the radio cell phone, maybe your cell phone go off first. And you know what do you do?
Roll.
Going on the record.
All rise to the court, please. Now, what we need, seated.
Good afternoon, Your Honor. We are on the record on Commonwealth versus Karen Reed on docket CR 117, beginning with the ADA. Can we have the parties state their appearances, please?
Adam Lally for the Commonwealth. Good afternoon, Your
Good afternoon, Mr. Lally.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. David Yannetti for Karen Reed. With me is my sister, Attorney Tanis Yannetti.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Yannetti. Good afternoon, Ms. Reed. Okay, we ready to start? All right. So what I'd like to do, the order I'd like to go in is, first of all, the Rule 17 motion regarding Trooper Proctor. So we did receive, and it was docketed today, an appearance of Attorney Michael DeStefano. And in his response to the defendant's motion, he tells us that Michael Proctor does not object to the defendant's motion for an order pursuant to Rule 17, seeking records from the Mass State Police Internal Affairs Division. So he doesn't object to that, so that motion's allowed. Any comment, Mr. Lally?
No, Your Honor, I would just say that the Commonwealth also does not object. Spoken to legal counsel from state police, they do not object. Whatever limited materials are available at this time have already been provided to counsel for both sides with the recognition of an ongoing obligation to provide materials as they exist. So no objection to that being allowed without objection.
All right, so that's one done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other two motions? Just a yes or no? And,
Yes.
okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay. All right. So I'll hear from you then, Mr. Yannetti, on your Rule 17 motion, seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. We learned that Brian Albert contacted his brother, Canton Police Officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay. I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton police were supposedly conflicted out of this case at that point.
So I want to know where that is in the record before me, because I think you know, as Massachusetts counsel, that the state police have jurisdiction over homicides, correct?
Oh, they do, yes.
So where is it in the record that they were conflicted out?
Those are in reports that the prosecution provided to us. Mr. Lally also told me that orally early on in this.
Okay, so I need those reports. I need that reference.
Okay, we're happy to provide that. Judge.
Okay, so I'd like it by tomorrow morning.
That's fine, Your Honor.
Okay.
So the Canton police had a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the brother of one of their officers? It stands to reason they can't. They appeared to recognize that. Yet Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena, but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified, before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the self-recusal of the Scranton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are.
You guys hear that echo? What the hell's going on? Hold on, you guys. That is crazy. Do. Oh my God, it's still going on. Okay, we're going to go to a different channel. Hold on. Wow. Hold on. Oh my God, all these commercials.
By the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from a keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all phone records. Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done but did not. We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, nobody can claim that anymore with a straight face. We now have testimony that these records exist, that calls exist, that text messages exist. As Mr. Lally said in the last hearing, phones do not lie. These phone records do not lie. We need them, and we ask the court to order them.
All right, it looks like you're asking the parties themselves to bring these in, though.
To the extent that they have them, that's accurate, Your Honor. We're also asking for their phone providers to
So
provide them as well.
they're two separately filed motions, right? And
Yes,
one of them is with Mr. Berkowitz, or former Chief Berkowitz, but he's not on the other. So I saw them as two distinct motions, and the one that we just heard you on, is really asking them to deliver whatever records, right?
correct. And I would note that the providers are on the second motion, except
But
for
that's three different people, or one different person on this.
one different person. So we have Higgins and we have Brian Albert on the first motion. We have Higgins and we have Brian Albert on the second motion. The difference is Berkowitz versus Kevin Albert.
Right.
Right.
Okay. All right. Mr. Lally, I'll hear from you, and then I do see Mr. Henning here. I don't know if he wants to speak or not, but I'm going to hear from Mr. Lally now.
Your Honor, just very briefly with regard to this motion. With regard to the Rule 17 motion with request to records or communications from individual cell phones from April 1st of 2023 to the present day. Firstly, the Commonwealth would just indicate the facts as recited in the defendant's motion the Commonwealth would submit are largely inaccurate. It's injected with hyperbole, injected with conjecture, in regard to federal grand jury materials, which belie much of what counsel claims that they say. Essentially unsubstantiated conjecture, which is directly contradicted by the testimony and the evidence contained within the federal materials. Now, I know that the court has had those materials and has carefully reviewed those materials, so I don't feel the need to go into each and every specific ground. However, what I would say, secondly, even assuming that everything contained within counsel's motion was true and accurate, the defendant's motion in this specific instance fails on two grounds. Number one, what the Commonwealth would submit is that the time period that's being requested is far too overbroad for whatever collusion or whatever purportedly occurred, according to counsel, going from almost a year worth of communications from people who admittedly, through the testimony and through the evidence that was presented and has been presented in both forms, knew each other well and knew each other well before any of this occurred and continue to associate and be friends following this incident. Secondly, the sort of last paragraph of counsel's motion claims that the records are needed to establish the exact nature and extent. What the Commonwealth would submit is really what they are needed for from counsel's perspective, is to establish the existence of these conversations and what the content of them were, which is the very epitome of a fishing expedition. And so for those two reasons, the Commonwealth would submit that the defendant has not met the standard under Lampron, and that motion should be denied.
All right. So I see Mr. Henning, so I don't know. Do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's here, do you want to be heard as well, sir? Great. So I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that,
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so out of an abundance of caution.
Okay, no, I understand you're following your order. I'm going to make it available. Not a party to any protective order.
Understood.
So we can take a recess. You can have them now. What do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
My apologies.
I'm happy to be heard now, and if the court will allow us to review the motion and the memoranda, we can amend with a written filing if there's something that we need.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Okay.
So,
Can I have one moment, Your Honor?
yes.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure. I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow, allows certainly, and I say mandates, that the third-party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all three record holders, or four if there's somebody here from Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address dovetails with what Your Honor is just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian
From the moment it leaves the factory, critical parts of your engine are building up deposits. And at Valvoline,
Was that in open court?
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, present is Peter Paschuko, and on behalf of Brian Higgins is William Connolly.
Great. Thank you. All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case. He has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I have represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right. Thank you very much. Counsel?
Good afternoon, Your Honor. Attorney Peter Paschuko on behalf of Kevin Albert.
All right, so you need to spell that last name
Sure,
for
it's
us.
P-A-S-C-I-U-C-C-O.
Good afternoon.
Yeah. Thank you, Your Honor. Just a little bit of background with respect to Mr. Albert, and we are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked, Any insinuation that he participated in a conspiracy or a cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals. And I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay, thank you very much. All right, Mr. Yannetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion. Mr. Lally, you didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide or you didn't comply with my order in providing the motions and supporting affidavits on this as well to the third party record holders and their lawyers?
Yes, Your Honor.
Okay. So the council will receive copies of this as well and be permitted to argue now and supplement it. All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury. And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them. And I've never seen a case where there've been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed. And it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt dialed Higgins, but again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall they're supposedly conflicted out of this case.
So I'm going to, there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking
January
for Brian
29th.
Albert, so January 29th to February 4th.
Or 4th or 5th, yes.
4th.
Fourth.
That's what you're
That's
seeking.
fine. That's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian Higgins, January 29th to February 18th. I need you to explain to me why those dates, why
Right, so-
February 4th and February 18th.
There was testimony in the federal grand jury that Berkowitz and Higgins were speaking to each other up through the 18th. With regard to Mr. Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit. Okay. All right, so go ahead. Thank you for answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call from or with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute, then another call with Albert for 10 minutes, then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's
So
supposedly.
I'm sorry, I just need to, so at that point, you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it, but somehow Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them, we don't have them. That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right, thank you very much. Mr. Lally?
So, Your Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a discrepancy in the dates that I'm not really finding any support for within the context of the motion. So
that's why I asked. So
my question was a different one as to the dates, though. So when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to anything occurring. So I'm not sure why anything on the 28th has any relevancy. There's nothing in the motion that I can glean that indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
What do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
All right. I'm going to hear from the third party counsel if they want to be heard.
Your Honor, if I may, just one further thing. I did speak with counsel. It's attorney Kenneth Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you. All right, so Mr. Conley?
Yes, thank you, Your Honor. Your Honor, well, With respect to our general arguments, we'll just rest on I'll rest on what I said previously. And we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony. But I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that that morning he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be relevant time period.
And so I will waive argument on that, Your Honor.
All right, and does counsel object to these records? Mr. Henning on behalf of Brian Albert? All right, and counsel on behalf of, oh, that doesn't concern you. Okay. All right. Thank you. Defendant filed, Mr. Yannetti, you filed a motion that I just got as I was walking out here.
Right, we're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's filed with a motion to impound as well. I figured I would hand deliver it today.
Okay,
The
great.
Commonwealth just got it today, so they'll need time to assess that.
All right, so today, all pretrial, non-evidentiary motions have to be filed pursuant to
Yes.
the order.
Yes.
All right, so this is it? This is what
No,
the...
I expect by the end of the business today, the court will be receiving a motion to dismiss to be heard next week as well.
All right, and you can't be here next week?
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California, Pro Hoc Vice. I don't know that it's necessary, but
I'm glad you filed it because I think it is if you're not here and you have to be here
that's
for
why we
that.
did.
So
That's why we did that, so.
Ms. Yannetti will, I'll allow that motion now that you have filed your appearance.
Thank you so much.
Okay. All right, so you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed the motion for reciprocal discovery. I'm not asking for any action on it, but I believe that would be it.
Okay, and I have one question. Are we all done with Bodie Labs? Have you received the information from them?
So on one part of the testing, yes.
Okay.
On the second piece of the testing, no.
All right, so I need a report on that orally on Tuesday.
Sure.
Where we are with that. All right, great. I'll see everyone Tuesday. Thank you.
Your Honor.
Thank you, Your Honor.
March 26, 9 a.m. hearing on all pretrial non-evidentiary motions.
All right. Brian? All right, Brian, we have a 3 o'clock list.
I'll come in later.
Okay, thank you.
You are muted.
I'm just being all nosy.
Oh, the Duarte one, attorney can't, she asked for Zoom, but now she can't do it. So we're in good shape.
I'm just being all nosy to see if there's going to be any drama in the room.
Goodbye.
Goodbye. Dang it. It's done. All right. Yeah, I noticed some channels couldn't get the whatchamacallit, the sound right. Kathy said that Law and Crime was on mute. The channel, one of the other channels I was on was Boston 25. They had a an echo. Okay, this is all I'm saying here. This is all I'm saying. That you can get the exact time and date of searches from iPhones. So this was Letitia's, this is just, you know, one page out of 32 pages of her searches. Her search on 1/25/2020. So yeah. That's all. That's all I was saying. So yeah, I think that her Google searches really odd at 2:49 a.m. and then again at 6 something. And then the taillight thing, like you were saying, they went back 5 times to get pieces. Okay. If something ain't right, I'm not saying, I don't know who murdered that man, that cop. Well, this is what uneventful. Right? Because we see the video of her backing out, okay? And I did not see nothing. Let's go look. Let me find the video. Hold on. I'll find it. All right. Let's see. Oh, of course, Court TV's got it. Hold on. Hold on. Oh, come on. I hate. Hold on. Okay, where is the clip then? Vinny? Vinny. I want to see the clip. Grandma, if you find it, let me know. Hi, May. Z. Okay. Has anybody found it? Because I'm not finding it, even though I've seen it many times. Oh, this is interesting. Oh, here we go. We'll watch that here in a minute. Let me save that. I didn't see this. Well, it was 7 months ago. I don't know what Vinny's doing. I'm trying to find some CC footage. Why can I not find it? Well, hold on. Maybe I just went forward too fast. Oh, it's exclusive. Exclusive. Oh, hold on.
Car.
Okay.
But the defense has a whole different theory about what happened here. I'm not calling it a conspiracy theory like in the negative way, but it's a theory involving a conspiracy. Okay, there's a difference. There's a difference. There's no one like landing from Mars or anything. There's a difference. But they are alleging some sort of a conspiracy. Now, for those of you who don't know what this story is, you need some more facts. Chanley Painter has the story.
John O'Keefe was the good cop, and he was a good man. That's why my client was with him.
Karen Reed is accused of causing the death of her boyfriend, Boston police officer John O'Keefe, after a night of heavy drinking. Prosecutors claim Reed backed her car into O'Keefe during a snowstorm and left him to die. But Reed's defense says the Commonwealth has it all wrong.
With each new piece of evidence that comes in, we're more and more convinced of my client's innocence.
O'Keefe's snow-covered body was found outside the home of another officer in Canton, Massachusetts. According to the prosecution's statement of the case, the couple was invited to the house after the bars in downtown Canton closed. Witnesses told investigators they last saw the couple at the Waterfall Bar and Grill. Others said they saw a black SUV resembling Reed's parked outside the house, but never saw O'Keefe come inside. Reed told investigators that she dropped him off at the after party and never heard from him again.
She went home to take care of the kids, and then she called him 49 times. Where are you? Why aren't you back? She was the one to go back to that residence to look for him. She was the one to find him. She was the one to try and keep him warm and give him CPR and try and revive him.
But Norfolk County prosecutors question those actions. They claim voicemails and text messages detail strains in the relationship and the victim's desire to end their relationship, including a voicemail from the night he died in which Reed allegedly told O'Keefe that she hated him. Also, O'Keefe's niece and nephew who lived with him allegedly told police that the couple fought constantly about the relationship and breaking up before his death. Prosecutors point to a broken taillight on Reed's SUV, pieces of which were allegedly found near O'Keefe's body, to suggest she ran her car into him. A forensic pathologist opined that significant blunt force trauma injuries occurred prior to Mr. O'Keefe becoming hypothermic. Cuts and bruises were found on O'Keefe's head and arm.
Somebody being hit by a car, I would submit, does not look like they had been punched out by Mike Tyson. And the victim here looked like he had been punched out by Mike Tyson.
Reed's lawyer, David Yannetti, says his client is not responsible for O'Keefe's injuries.
I believe that the evidence shows that she didn't hit him. I've said in the past that his injuries are not consistent with being hit by a vehicle. And by the way, the Lexus taillight breaking, coming in contact with a human being and not a hard surface, makes no sense to me. I think it's going to make no sense to a jury.
If not Reed, who? Her lawyer says that there's a lot they still don't know.
This is a case where the homeowner, being a Boston police officer, was treated differently than he would have been if he were you or me.
Right.
Okay, bottom line, this trial hasn't happened. I haven't seen the evidence, so I don't know what happened here. I just know what the prosecution is alleging here. But let's bring in Court TV legal correspondent Chanley Painter to talk about what the defense is alleging here. What is their theory?
Oh, come on, Vinny. Where is the footage? That's all I want. Where is the footage? Because the title says exclusive footage. I don't see it. Is this it? Here we go. See what happens.
Reed was staying the night. So she, this is what the video, here it is, Vinny. So she's pulling out in the black SUV. And that's the victim's SUV parked. And the defense says that she makes contact, hits the victim's SUV right there, damaging that back right passenger side tail light. And they also claim you can see, the victim's SUV move, indicating that there was a collision. And then as she pulls away, they say that you can tell there's missing parts of the taillight cover.
Right, but it would have been missing if it was a result of striking Officer O'Keefe at that time also. Here's a closer look at it.
Oh, Vinny.
Once again, as we're backing up here, keep your eye and see if you see any movement here from the other car. It's very possible. It's very possible.
Prosecution doesn't say there's contact.
If the whole case was, how did the tail light get broken? You've got reasonable doubt right there.
Reasonable doubt, yes.
You've got reasonable doubt right there because you can't tell, but it's very reasonable to think that at that point you could have broken that tail light.
Yeah.
Okay. Wow. And that's defense evidence that we got our hands on. Great job. Okay. Today's hearing, anything else?
Okay. Let's watch this here real quick. Oh no. What'd I do with it? Hold on. See, I don't know what to think about her. I don't know her. I don't know much about her, but from the way she acts, let me think how I'm going to say this. She seems to think she's better than everybody. There you go. That's what she puts out there. Okay, I cannot find it now. Shoot, I knew I should have just watched that one first. Hold on. It's a CCTV of them at the bar. Sorry, I'm not looking at chat yet. I'm trying to find that. Where is it? Okay, here it is. Hold on. All right. Here we go. I think she's in this clip too. The stuff we are watching, except for the new recent one, is from 7 months ago.
Friday night in January 2022, Karen Reed and her boyfriend, Boston police officer John O'Keefe, joined friends for drinks.
We were happy, having fun, laughing, just very normal.
Did you ever feel you were overserved that night, as
No,
they say?
no.
Later, Karen and John were invited to the home of a fellow Boston cop. Neither knew him well. What happened next is disputed. Karen says they pulled up to the house and she waited in her SUV while John went to check things out. She says she watched him go to the door, put his head inside, then nothing.
I texted him, I called him, and within minutes of him exiting my car, is not answering his phone. Minutes. So
What happens next?
I left.
She drove home, fell asleep. When she woke early, John wasn't there. She went out searching and 6 a.m. found him lying unresponsive in the snow and bitter cold in front of the home where she dropped him.
His eyes were swollen shut. He had blood dripping out of his nose.
Hold on. I just want to be very careful and mute this stuff because now that, okay, when certain cases, you know, get in mainstream media, everybody wants to protect their videos and give you strikes. It's pretty crazy if you ask me. All right. Hi, Miss Barbara. It's just the magnitude of the supposed cover-up is beyond. It would take so many departments. Thin blue line. You know what? I said that about whose case did I say that about? Oh, I can't even think. And I was really shocked to find out. Oh, it was Lori Daybell's case when they said they're keeping everything close to the vest, and they had a court order to have the files sealed, the documents. And here, when everything became unsealed and the hearing, there wasn't anything extra. It was already out there. Already. There wasn't nothing. I think there's some dirty cops out there. Yes, I do. No, actually, I don't know if I would say cops. I would say the DA's office. What happened with Karen? From the start, to be honest. Yes, she does, don't she? We went that video a few times. I just don't see her hitting the car. Did you see though the tail light though? I didn't see her hit it either. But the tail light, there is something wrong with it. Unless it's a streak of snow going down it, or icicle, I mean. Right. It'll be interesting. Because if anything, she could have hit him, okay, and not realize it. When would she have hit him though, if they got this footage? I don't know. And those people, that cop's house, he lied. Correct me if I'm wrong, Kathy. You seem to know this case better than me. He stated that, okay, he had cameras, but it hadn't put him up yet. Wasn't there some kind of something, did he lie? Did he get rid of them or what? Yes, I know. I think it was 249 and then again at 6 something, but I'm not 100%. But I know 249. Why would that Jennifer lady, Albert lady do that? And everybody was cheating on each other. Oh. Why did one of the family members of the cops do a research on her computer? Because it came from an iPhone. And it wasn't Karen's iPhone. Right. But she would have when she first went back to the house. I like to hear her phone calls to him, calling. This case is so crazy. You know what makes it crazy? Because YouTubers got involved. Okay? See what happens? It gets messy. Oh, God. Look at Summer Wells' case. Look at Gabby Petito's case. Look at, what's that sweet little boy? Quentin Simon. And look at it. Look at the mess. Okay, let's look at this a little more here, because I don't know what this is supposed to be. Did she take those pictures or what?
Out her thoughts as first responders arrived. Did you say, I wonder if I hit him? Did I kill him?
I said, could I have hit him?
The Massachusetts State Police concluded Karen did hit John. Their version, Karen and John argued in the car. John got out, Karen backed into him, hit him, and drove away. Police say they discovered pieces of a broken taillight at the scene. In court,
hold on, I wanna
a prosecutor read from a first responder's interview at the scene.
Where? Shoot. Where is that? Hold on. Let's look. Yeah, I'm pretty interested to hear about that too. Yep, for sure. I just know what I feel about her is she's thinking she's better than everybody, and something's going on with the DA's office. Don't know what it is, but I don't know. Okay, let's continue watching this. Trying to figure out what area they got this from. This picture.
They discovered pieces of a broken taillight at the scene. In court, a prosecutor read from a first responder's interview, quoting Karen.
Defendants then made several statements to her indicating, I hit him, I hit him, I hit him, I hit him.
Karen was charged with second-degree murder. She pled not guilty.
I have an innocent client. Period.
Alan Jackson, Karen's high...
He is a good attorney. I will say that. I like this guy.
Profile attorney believes John was set up that night.
John walked into an element of hostility in that house.
He has argued in court there were people in the house who had a troubled history with John.
John O'Keefe got out of a car, walked into the house, was sucker punched, fell, hurt himself, and then ultimately his body was moved.
The defense claims a cover-up.
The Massachusetts State Police is involved. There are people that were in that house that are involved.
Prosecutors deny that. They filed a motion demanding defense attorneys stop talking to the media. Both sides are due back in court on Tuesday.
Okay. What's so funny about that is that they did get caught in lies. They did lie. It was proven the last hearing, you guys remember? Turtle Riders. Oh my God. Do they? No. No, you said, oh, I thought, I'm like, did I say that? I don't remember saying that. When did I say that? Does everyone trust her own? No, I don't. No, I don't. Benny did an interview with a guy named Turtle. Yeah, Turtle Boy. That's who we're talking about. Yeah. He's acquaintances now with Karen Reed. But you know what? You can be friends with whoever you want. That's not a crime here. Which they tried to make it a crime, though. He's on court TV right now. Oh, come on. Okay, hold on. Let's go there. We got to see what's up. Hold on. Let's go look. Court TV, court TV. Hold on. Where? Okay, let me go to their website. Maybe it's there. Because it's not on YouTube. Watch live. Let's go there. Courtroom coverage. Hold on. Where are you seeing them interviewing? I'm not finding it, Miss Barbara. I know he was interviewed a week ago or so, but as of right now, I'm on their website. They're not live talking about it. And on YouTube, they're not live. They got one from March March 1st and the 4th. The March 1st and the 4th, though, they're playing old stuff. He was on there March 4th. Oh, what's this, Grandma? You sent me a link for what? What's this? What's this to? Okay, hold on. I gotta go on YouTube to my comments from you. Okay, here we go. I'm sorry. You guys can see I'm behind on the comments. I'm sorry. Okay, Grandma sent me a link. Let's go to it. See what this is about. Oh yeah, the court documents with Turtle Boy. Yeah, it's funny. It's funny. It is.
In that search warrant application, claiming that Karen Read fed information about her case that was not available to the public to Aidan Kearney, the controversial blogger known as Turtle Boy. In the past, her lawyers saying publicly they hadn't spoken with Turtle Boy. The blogger saying the same. But these documents say that isn't the case and that they've been in touch for a while.
Karen Read is with me.
Karen Read's lawyers talking outside the courthouse after a hearing in 2022. Her lawyers by her side in court over the year plus since she was charged with murder in the death of her boyfriend, Boston cop John O'Keefe. Prosecutors say she hit him with her SUV outside a Canton home and left him for dead. But her lawyers say it's a cover-up, that O'Keefe was beaten inside the house and bitten by a dog. We love you, Aidan! That theory picking up steam after controversial blogger Aidan Kearney started talking about it on his blog and in videos, until he was jailed last month for witness intimidation. Now, a new search warrant application filed by state police says Read was feeding information about her case, not meant for the public, to Kearney, who posted it on his blog. According to state police, Read, her lawyers, and Kearney have publicly denied being in contact, but documents claim they'd been in touch for months, even meeting for lunch, saying Kearney texted a friend of Karen Read saying, quote, "We had a great time." State police say Read had used a friend to get Kearney unreleased documents, photos, and grand jury details, but say when that friendship went south, she started talking with the blogger directly, saying the two shared 189 phone calls, talking for more than 40 hours. Now, we've reached out to Karen Read's lawyers who say they're not commenting at this time. Live in Dedham, Emily Malha, WCBB News Center 5.
Emily, thank you for that.
I'm on Court TV's website. They are not live with anything to do with Turtle Boy. So here is March 4th and the 1st, Turtle Boy. And then he did another one before he went to jail. Let's see, what date was that? February 1st. Oh, that's icky. December 27th, December 22nd. This is a 32-second clip. That's it. There's nothing else. So I don't know where. Because I went to watch live. So, okay, let me look at the comments now. Okay, I think the link above. Well, kids are needing some attention. See y'all later. Oh, thank you for being here, Kathy. It's going to be proven not dog bites. No dog DNA. In fact, the defense has now refused to dog the DNA in court papers. Really? She did. There's been a SS. Oh my. Right? Let's go look at another interview with Karen. Here we go. Wow.
Outside this courthouse in Canton, Massachusetts, supporters swarmed around Karen Read, charged with murder in January 2022 death of her boyfriend, Boston police officer John O'Keefe. Read
Okay, I
strenuously
comment here. Could you imagine fighting like this for someone you don't even know? That you put your whole family and your life aside to do this? I could see if I lived out there and had to deal with that police force or whatever. I don't know. It was just a thought I had. All right, I'm going to see that of the dog.
Defense, bare-knuckled and bold, is making national headlines. Her lawyers alleging in court documents that a fellow police officer was involved in O'Keefe's death and colluded with other people in a cover-up.
You're alleging that law enforcement officials in the state committed murder and that they're covering it up. Why would they want to be involved in this?
Because he's dead. I think things went too far. It was late. There was alcohol involved, but they're all family. And there's many of them involved.
After posting bail, Reed has spent much of the past 18 months in and out of court awaiting a trial date.
And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Prosecutors allege that Reed...
Hold on. I'm going somewhere. Turtle Boy is on YouTube, and he's been streaming. Okay, he's not streaming right now, though, but he was streaming this. All right.
Reed hit O'Keefe with her car after getting into an argument earlier in the day, leaving him to die in the middle of a snowstorm in January 2022. But Reed says she had no reason to harm her boyfriend.
I would call him the patron saint of Canton. He was just very selfless, frugal, and I think you'd be hard-pressed to find anyone that didn't care for John.
The couple first dated in their 20s and reconnected more than a decade later in the middle of the pandemic.
So how did you meet up again?
He had reached out to me on Facebook and he said, "Hey, blast from the past, how's things?" And when I saw his picture, his profile picture was with several young children. And then it triggered my memory that his sister and his sister's husband had passed away. And he told me, yeah, I have the kids now. I admired that. I thought that was amazing.
Soon, Reed says she became part of the family, often sleeping over at O'Keefe's house and helping take care of the kids.
He would go to work and I would stay with his niece and nephew. All of the breaks that the kids had, we did something.
But their relationship...
All right. It's not on their website. It's on Pluto TV. No, Miss Barbara, come on. This is what I do. I don't even have YouTube TV. Remember the only way that I watched it before, remember you called me on the phone and I listened. They're talking about the dog bites. Yeah. From you know what? I have all the documents. I should find them. I think it's in my other laptop though. Of this case, because I think when I read, maybe it's in my Google Drive. Hold on, let me look. All right. I recall hearing that she was sick and tired of watching the. Yeah. Oh God, ouch. Do you know a lot of people? I've heard a lot of the protesters that are out there. A lot of them don't go there no more because they're afraid they're going to get arrested. All right, hold on. Well, maybe I'll find it. I don't have time to be doing this and wasting your guys' time. I can't find it. That's not live then. It's on replay. But yes, that is covered. Yeah, I remember the Turtle Boy being on there and talking to him about the dog bites on a previous broadcast. Let's watch the most recent one. Oh, let's finish this.
Relationship also had its struggles. Reeve says O'Keefe had been relying more on her to take care of the kids, and that he criticized some of the decisions she made with them.
We had an argument on New Year's Eve. We were on vacation, and he became incoherently drunk. And I ended up ringing in the new year with his niece and nephew. John didn't come back to our room till after 3 a.m. So that was rough. I felt very much taken advantage of. He apologized profusely for what happened on New Year's Eve. And he said, if you can't get over it, then you need to spend some time at yours. I can't keep apologizing. I don't want to keep rehashing this.
A few weeks later, they were invited to meet up with some friends at the Waterfall Bar in Canton. And there, they ran into Brian Albert, a fellow Boston police officer who Reed says O'Keefe looked up to. Albert had led the city's gang unit before commanding the Fugitive Apprehension Team. It was the elite squad responsible for taking down some of the city's most dangerous criminals and featured in the 2013 TNT show, Boston's Finest.
1 minute we're walking around, everything's fine, and then 1 minute it's not fine.
Open the door to a world of opportunities. Earn your accredited high school diploma online with Penn Foster.
He's a big guy.
Both times I met Brian Albert, he seemed like the type of person that you'd be surprised he's out socially because he doesn't seem like he ever wants to be there.
But at the bar, Reed says there was an invitation to continue.
Oh my God, did you hear her? Oh my God. I think it's interesting, but you know, so much ickiness is coming, from him, that I just started covering it. I mean, I've always, been watching it, but not talking about it to the public. You know what I mean? Yeah, that's your dude. Who are you talking about? What's the date on the interview? What is Turtle Boy wearing? Tell me what he's wearing.
Continue hanging out at Albert's home.
I said, can we make sure we're welcome here? Nobody extended the invite to me. I didn't hear the invite extended to you.
They drive to the Alberts' house. What happens next is disputed.
So I pull at the foot of the driveway. It's snowing. John has no coat on. It's windy. So I drop him off. He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him before, she says, she fell asleep around 1:30 in the morning. She then says she woke up before 5 a.m. He still wasn't home. She then started canvassing the neighborhood.
Just going to drive around in the 2 square miles that we spent the preceding night.
After 20 minutes of unsuccessful searching, she called John's friend, Carrie Roberts, and Jennifer McCabe, Brian Albert's sister-in-law, who was also at his house the night before. The 3 women together now headed to Albert's home.
How soon was it?
See, and that's the other thing too. Albert there lied about Jennifer spending the night at the house. Albert done a lot of lying. Yes, he did. I know, Miss Barbara, can you imagine that? That somebody in law enforcement would lie? They don't lie. No. Not law enforcement.
That when you pulled in there, that you saw John's body?
Immediately. And what struck me when I saw him was his mouth was open a little bit and his eyes were shut and he had spots of blood in different areas on his face.
O'Keefe was taken to the hospital and pronounced dead. He died from blunt force trauma and hypothermia. And it wasn't long before Reed became the #1 suspect. Authorities say they had noticed a cracked taillight after they seized her car.
I had told both Jen and Carrie that I cracked my taillight. I said I just hit my car on top of everything, but I didn't look at the damage. And both women said, it's cracked. It's cracked. Calm down. You cracked your taillight. You're okay. Let's go look for John.
But according to police statements, Jennifer McCabe told authorities that while they were looking for O'Keefe, Reed stated, "Could I have hit him? Did I hit him?" And when O'Keefe's body was discovered, first responders who arrived on the scene say they overheard Reed make other statements.
Firefighter said that you said, I hit him, I hit him, I hit him.
I said I hit him. It was preceded by a did and proceeded by a question mark. What I thought could have happened.
Nice. Boy. Did you see that scary look on her face? Woo. I just started to recently. I mean, I know about this case. I've read the documents on it. So I've been keeping up with it. Could I have hit him? Yes, question mark. Oh, Nala. Come on now, Nala. Nala, why you do that? You're too hot, dog. Sweet girl, Nala. Yes, you are so sweet. All right, let's continue.
Was that, did I incapacitate him unwittingly, somehow, and then in his drunkenness, passed out?
When you walked out of the bar, how many drinks had you had?
I had probably about 4.
The Commonwealth says that you had 9 drinks that night. That's what the prosecution says.
I don't believe they're saying I wasn't in my right mind.
Well, they were saying you were intoxicated. Is it possible that you might have hit him unwittingly in your admittedly very large SUV?
No, not possible.
3 days after O'Keefe was found dead, investigators arrested Reed for manslaughter. She was eventually indicted on second-degree murder. Investigators reported they found fragments of broken glass on the rear bumper on Reed's vehicle, and that a broken cocktail glass was found by what appeared to be patches of blood near O'Keefe's body.
The victim, Mr. O'Keefe, is last observed on surveillance video with a cocktail glass in his right hand. Same arm that's injured, the same type of glass.
I probably will be, when this does go to trial, I will be streaming it like the rest of the world will be. She didn't. Jennifer did. Jennifer McCabe. Jennifer, that's why I've been saying in chat. Jennifer, is that how you say it, girl? McCade? Karen did not do that search. It came from Jennifer. She was in the house that night. And she made the 2 searches. No, I know, right. Right. Never. Thank you. McCade, right. I don't know, but hopefully this cop gets some kind of justice. No, they don't. Because, ever since when we find out that we have rights to, look at documents ourselves, we can request everything ourselves, things have changed and turned a little bit. You know what I mean? And cops aren't all that they used to be. You know what I mean? People have always been afraid of cops. And it shouldn't be like that. Thank you. You know the right words. Transparency. Yep. All right. Let's continue.
That is then recovered from the bumper of the defendant's car.
In court documents, the prosecution also claims that Reed's blood alcohol level could have been between 0.13 and 0.29%, above the legal limit of 0.08. In addition, they say,
Okay. If that's a fact, did they do a test on her? Do they got proof of that? Did they do any blood draws when they arrested her the following day? I don't trust the DA in that county.
pieces of Reed's taillight were found on the scene the day O'Keefe's body was discovered. More fragments of that taillight were found the following week, according to Canton police reports, after the snow melted, which revealed more at the scene. But Reed's attorney, Alan Jackson, has a different theory about how those fragments of taillight got there.
Those pieces of taillight were placed there after the fact.
You're saying evidence was planted?
The pieces of taillight were planted after the fact.
What does the defense believe actually happened to John after Karen dropped him off?
I think he walked into the house. I think he was confronted, was likely brought down to the basement. I think that confrontation got physical. and he was beaten. He was beaten to a point of unconsciousness.
Jackson argues that the autopsy photos of O'Keefe support his theory and not the prosecution's claim.
Looks like he's been in a fist fight and he's been beaten. He's got some defensive wound bruises on the backs of his hand. He's got this massive laceration on the back of his head, a big giant gash, about 2.5 inches, exactly lateral, going from left to right. 2 black eyes, cut over his right eye, cut over his nose. This was a cover-up that John was murdered inside that house. His body was placed outside.
But in a statement to ABC News, the prosecution says there was
That guy was beat. Wow.
no conspiracy or cover-up. Such claims have been systematically refuted by evidence submitted to Norfolk Superior Court. The prosecution also said that, according to O'Keefe's cell phone GPS records and 11 witness statements, O'Keefe never entered Albert's home.
Of course
and that
not.
a medical examiner found no signs of Mr. O'Keefe being involved in any type of physical altercation or fight.
There's no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds.
ABC News reached out to attorneys for Brian Albert and Jennifer McCabe, but did not hear back by the time of this broadcast. In a previous statement to the Boston Herald, McCabe's attorney said the whole scenario is baseless. Reed is scheduled to appear next in court again in September.
So there's that. Yeah, there's some kind of cover-up going on here. You got dirty DAs out there. You know, and like they said in court, that one Albert guy, he got special treatment. Even though this happened at his home, his property. I'm looking for something. You know, I just did something recently on the convicted killer, Gypsy Rose. Okay. That video where she was taking accountability, right? I just seen somebody did a clip saying she had to do that to stay out of jail. Oh my God. For real? I don't know if it's for real. I'll find out though. Who said you're rude? I didn't say nothing. Yes, the convicted killer, Gypsy Rose. She murdered her mother. Have you heard? Girl, do you remember when I thought she said the N-word? I'm like, well, that's racist. And she was saying the M word. Why can't you say it? Why can't you say it out loud? Convicted killer, Gypsy Rose Blanchard. Of your mama. Tell me how that's okay. I made a mistake. Yeah, you know, I let him on for a couple years. And then she said, and then Gypsy said, pay attention, guys. I'm going to show you something. Because Gypsy said, I'm going to show you. Hold on. That's what Gypsy said. Pay attention.
I will use the one card that I have over you. Gypsy, I will use the one card that I have over you. Gypsy.
Did you hear that? I'm holding one card over you. It's Gypsy. See? She's a little cray-cray, you guys. Very dangerous. Let's look at some more here. Ooh, hold on. Where is it? Gypsy, the convicted killer of the murder of her mother. Hold on.
It's Mayberry. We're moving to Mayberry.
It didn't take a lot to convince Dee Dee and her daughter Gypsy Rose to make a new home in Aurora. They already knew it was meant to be.
It is the perfect town, the perfect place.
I think it was a blessing in disguise. It took something like a hurricane to make us have a happy ending.
Dee Dee was happy enough just having medical care for Gypsy. She says she never expected this.
It's amazing. It's amazing, the outpouring of love and support.
Dr. Janet Jordan met Dee Dee and Gypsy while on a mission trip to the hurricane-ravaged areas. She says she knew right away she'd see them again.
They're like lost souls who are meant.
Okay. Do you guys notice if you ever watch anything with her in it, she makes sure she's facing the camera at a certain time, that she's doing it right, that she's got the camera's got their eyes on her. Have you noticed that? Watch her eyes once. She'll look right to the camera at certain times. I know. But yeah, anyway, so somebody, not this one. Let's see if this is it. What is this? This here is a video that was from her cell phone of showing her boyfriend where her mother's room is and how to get there.
Hi, honey. I'm doing it. He's eating a brownie. But later.
Sorry, that's the wrong one. Okay, hold on. This is it. She's walking to her mom's bed, showing where she sleeps. Look at that. Look what she did with her hand. She did that. She caused all that. I don't think she should be able to make any money off her crime. None whatsoever. I think she should have to pay all those people back. You know, like that that place that gave them that house. They didn't have to pay for nothing. She should have to pay them back. All that should go to them. Oh my God, I know. Hearing her cry, he is sick. He's going to get the same treatment, you guys. Oh yeah, they're waiting for him. They know. Yes, that and the neighbors in the neighborhood bringing him food. I mean, and just sit. Oh God, I gotta shut up. I'm just gonna shut up. I don't see, I've never seen her apologize to her mother. I'm going to be honest, to her mother for what she did to her mother. I have not heard her apologize to her neighborhood of what she put them through. She didn't even apologize to Nick. Sorry, I made you do it. And she can't admit she's a murderer, so. I did a bad thing, but I did my time. Yeah, but you're still a convicted murderer. The lady who, I know. Right. Nope, she won't. She won't even say that she's a convicted killer. I will. I will. If she didn't come out of prison acting like her shit don't stink, what she did, she used people within the court, or not the court, the jail. She was doing the same shit in prison as she's doing now. She took advantage of this girl for I don't know how many years, that she's the one that got Gypsy all those subscribers. And then when she found out that she was getting paroled, she cut off all ties to that girl. See? And other people are coming out with information of communication with Gypsy. See, these things are in black and white. You know, there's proof. You can't say people are making it up when it's actually, you can see it. No. Dang right she does. You can tell. She's talking about, I want so-and-so to play me in a movie. Oh, that'd be awesome. And I'm like, wow. No, I haven't watched The Act because it doesn't portray it. I know it. I lived it. Well, yeah, she has some mental health issues. Yeah, definitely. And there was abuse going on there. Okay, you guys, I'm going to get going. I'm going to get something to eat. I haven't ate. All right. Thank you for being here, Miss Barbara, Grandma, and everybody else who came through. Okay. Love you guys.